Testing 1 2 3, 1 2 3, testing.
Good morning and welcome to the first Wynne Jones IP in Practice webinar. The webinar will begin in a few minutes, so please take this time to familiarise yourselves with the webinar interface. As you will see, there is a facility to submit questions via the text box on the right of the display screen. Please feel free to submit questions at any time. We will attempt to answer as many as possible during the webinar. If we are unable to do so, we will follow up by email in the days following this webinar. Good afternoon and welcome to the first Wynne Jones IP in Practice webinar, The Not So Secret World of Trade Secrets. My name is Martin Hayden, and in this webinar I will be discussing various aspects of trade secrets so as to assist in understanding of what they are and how they are used in business. This is an interactive webinar, so please submit any questions using the text box and we will attempt to answer them at the end of the webinar. So let's now turn to the topic for today, the not-so-secret world of trade secrets. The purpose of this webinar is to introduce the concepts relating to trade secrets and how they might be used in practice. During the webinar, we will discuss what are trade secrets, where you find trade secrets, how trade secrets and other intellectual property rights interact, how to protect trade secrets, and how to deal with the trade secrets of other people. So as a brief introduction, many businesses identify trade secrets as key business assets. In an EU study in 2013, in preparation for a 2016 directive on trade secrets, 75% considered trade secrets to be strategic business assets. 52% of the survey used the assets to avoid disclosure of specific information, and yet 60% of those studied said that they shared trade secret information with third parties. So there is clearly an interplay between the need to protect trade secrets and to use them and disclose them. From experience, few businesses have a policy for handling trade secrets that is discreet and understandable. It is often ad hoc, and as we'll see, this can have certain impacts later. But for all this, we have found that courts are prepared to enforce trade secrets by awards of damages and injunctions. And so the issue is, how do you place yourself in a good position to be able to use these procedures to the benefit of your business? So we move on to the first part. What are trade secrets? The definition that we have here is based on TRIPS Article 39. TRIPS is the WTO agreement on trade-related aspects of intellectual property rights. And the basic definition that is used is that a trade secret is information that is not generally known to the public, that confers economic benefit on its holder because the information is not publicly known, and where the holder has made an effort to maintain its secrecy. So this is a fairly standard definition. Variants appear of this around the world, but these three basic principles tend to apply everywhere and are a good starting point to say, how will we manage trade secrets? One aspect that we will not go into detail but need to remember is that the laws vary around the world as to how trade secrets are protected and how it is possible to prevent or compensate for disclosure without consent. Some countries have a specific trade secret law, for example Switzerland. Some countries have laws such as unfair competition laws, which can be used to deal with trade secret issues. Examples of those might be Germany or Austria. Trade secrets can be dealt with in intellectual property codes. Countries such as France and Italy do that. And there are countries such as the UK, Ireland, Malta, where it's principally handled by terms of contract law and confidentiality. As a general rule, in most countries, trade secrets are not considered to be an intellectual property right. While they are often grouped together with intellectual property rights, they lack one of the common features of intellectual property rights, which is the need for some form of originality or creativity. The issue about trade secrets is that it is secret and has value because of its secrecy. So it is not reliable to say intellectual property rights include trade secrets. They really need to be dealt with separately. So let's move on to this definition in more detail. The first aspect, it's not generally known to the public. It's many ways of saying secret or confidential. What this means is that the information can't be generally known or readily available to anyone without restriction. Merely the fact that no one has looked does not mean that it's not available. It must be that it can't be impossible to get access to it. Or the access comes with some form of restriction. We'll talk about those restrictions later. Public doesn't just mean general public. It can include a very large group of focus group, but if they still have no restrictions on access or use of the information, they are likewise considered to be public. Now this begs the question, how many people can you tell a secret to before it ceases to be a secret? So very large groups are also a danger, even though there may be some limit to membership of that group, unless there is restriction. And the final part is that once something is no longer secret, you cannot restore trade secret status. You cannot get that genie back in the bottle. So there is a real problem which, once a trade secret is out, you then have to look somewhere else. Trade secret laws will no longer apply. The second aspect of the definition is that the trade secret confers economic benefit on its holder because the information is not publicly known. So the value must come from the fact of secrecy. And this value may be the ability to charge a higher price, the ability to run at cheaper manufacturing costs, or the value might be because you know the source of supply at a certain rate. The value might come from knowledge that there are customers who are prepared to buy products or services, and the value might come because you know the capabilities of your product or service that other people do not. But the value comes from the secrecy, not from other aspect. If there is no commercial value to the information, it is not a trade secret. So personal information held on employees or customers may be confidential, but has no commercial value. Examples might be people's personal addresses, their emergency contact details and phone numbers. Whether it's employees or customers, there is no commercial value in that, but it may be necessary for the effective running of a company. So it's treated as confidential, often very strictly so, but it has no commercial value. And also we have to consider the interplay with things such as the GDPR rules on how digital data is stored. So again, we then come to the question of, well, what if the value in this information actually comes from an exclusive contractual relationship rather than from secrecy? This is an open question. The answer may be that the exclusive contractual relationship maintains a level of secrecy and so achieves that. But if you've got a value in a piece of information, just because you've agreed between parties that you're the only people going to work on it, doesn't necessarily mean that the value is from the secrecy. It might be a commercial one. So it's not an absolute that just because you've got a piece of confidential information in business, it will be a trade secret. The final part of the definition relates to the holder making efforts to maintain secrecy. So your activities as a trade secret holder determine your level of protection, because those activities will define what you mean by secrecy and what restrictions you place on the use of this. If you make no effort to maintain secrecy, then it may not be a secret. It may just be a piece of information that no one has accessed. But if it's accessible and uncontrolled and you make no effort to control it, you may not be a trade secret and therefore may not be available to protect. It requires positive action. You don't automatically get trade secret protection by merely claiming secrecy or confidentiality. It may require that you set up an environment that starts by being secret or confidential, and that will therefore help it. But merely stating that something is secret does not make it secret. You have to do something to maintain that secrecy. And the normal practice in a domain may affect how actions are interpreted. And the example here is it common to exchange confidential information for safety purposes? There is a recent case where this was considered. The businesses exchange details of the safety aspects of their different systems to work together for certification purposes. And in fact, a court held this was quite a normal way of exchanging confidential information and trade secret information, even without any specific agreements or restrictions placed around it. So we'll move on now to consider, where do you find trade secrets? We have a list here. It's not exclusive. R&D results quite commonly are trade secrets, particularly if conducted in a confidential environment. Technical design data, confidential process parameters of processes that are run behind closed doors. But then you can go into failure analysis, why things have limits, how they behave, and comparative test data. These may all be trade secret and may be important because of the understanding that they give. But moving on from the technical side, you can think of marketing studies, commercialization plans, survey data. All of these can have distinct commercial value and be a trade secret. Pre-release designs and trademarks, in other words, these aspects that have to be public but before they're made public, may be valuable trade secrets. And you will often find companies going to lengths to conceal designs before they actually make releasing of products or services to the market. Commercialization plans and marketing studies can be very valuable. They're often very expensive, and the information they provide can be exclusive and provide a very important value, which that secrecy maintains. And then we move on to financial data, customer lists, supplier lists, material prices, inventory and stock levels. All of these things can have value, commercial value. Knowing how your company is performing can be very important commercially in the way people deal with you. The knowing of your stock levels can affect prices. One of perhaps the most obvious levels of this sort of inventory and level, you might consider an oil company. Its reserves are probably its most valuable piece of information, and the better it knows that, the better it can plan and project its prices and its activity. So you can find trade secrets in many areas of business. This is not just technical, it is commercial. Now let's quickly look at the interplay between trade secrets and other intellectual property rights. Trade secrets and intellectual property rights are not mutually exclusive, even though I have said trade secrets are not, by definition, intellectual property rights. So you can have trade secrets embodied in certain aspects of intellectual property rights, but in many cases there is an interplay between the need for intellectual property rights to be made public and the necessity of secrecy. As a general statement, there are always trade secrets. At some level, every business will have some aspect which is known only to it and which gives it a bit of value. They may not be large, they may be very detailed, but there will always be some trade secrets somewhere. And within intellectual property rights, generally by definition of the need for some sort of creativity and originality, things generally start as a trade secret. And so the need is to balance the automatic trade secret status, the thing that comes because you've created that confidential environment which gives you the secrecy, with the need to take action to register intellectual property rights, which is usually done in a public forum. So trade secrets and IPRs work together. A good policy needs to address both and recognise the impact one has on the other. As a general view, trade secrets are not free. Even though they may come into being automatically and you may have created some sort of environment that creates secrecy around them, it's necessary to devote resources to protect trade secrets in the same way that you have to devote resources to protect registered rights. So these resources might be effort in the sense of creating a secret environment and maintaining secrecy with a work environment. And it can be involved in terms of cost, of auditing and understanding what you've got and making sure this is kept up to date. So the idea that if you do nothing, you've always got trade secrets and you don't have to worry about it because you don't need to spend on them is untrue. If you're going to rely on trade secrets, you need to put effort into maintaining your trade secrets, and we will look at some of those later. The balance between trade secrets and intellectual property rights might shift over time. So it's interesting to consider where, at an early stage, intellectual property rights might be more valuable because these are the very early stage bits of information that will allow you to scale your business, whereas trade secrets may be more valuable in the longer term to sustain a market benefit that you've already got from established positions. This may not be a general thing across the whole life of technology or a business. Particular parts may move in particular ways and need to be considered in relation to one another. So let's look at trade secrets and patents first. As a general view, all patents start as trade secrets. The requirement for a patent to be novel, in other words, not new to public at the time it's filed, means that it must have been secret beforehand, and it is presumed to have value. And the value that it would have as a secret is that it is possible to get the exclusive rights and therefore maintain exclusivity in the market afterwards. So all patents start as trade secrets. Quite often when people are considering patents, one of the discussions will be, well, do we patent it or do we keep it as a trade secret? We'll consider later whether you actually need to make this either or decision, but in fact, a more sensible approach is we start with a trade secret, should we then decide to patent it? So the decision on trade secrecy needs to be made before the decision on patenting, because if it's not a secret at the start, you can't then patent it. One of the big issues with patents is that the contents of the patents themselves and their supporting documents become public. At some stage in the life of a patent, things will be made public and publicly accessible without restriction. So what's important to do with trade secret is consider the content of your application and whether or not it is necessary to put that trade secret in the patent application to satisfy the requirements of patent laws. Are there things that you can hold back that are valuable and important and yet are unnecessary for properly describing the invention and disclosing what you know? And again, if it is in a patent application, you need to be aware of the consequence from loss of trade secret status when that application is published and when those documents are published. So again, it's not just the application, but it's the supporting documents. If they contain trade secret information, they will usually become publicly available when the application itself is published. And you may not be aware of this. So thinking of content is very, very important. So the interplay with trade secrets and patents can be quite interesting, where you have a later developed variant that falls under a patent. But because it's later developed and new, it may still have a trade secret status. A patent can cover a broader concept, whereas a specific implementation may be the subject of a trade secret. And so often the case, what actually is commercialized or processes that are actually run will involve more than the invention. And these aspects may be the trade secret part. So one takeaway is that trade secrets and patents, everything starts as a trade secret, and it's not necessarily an either or situation. You can consider having both of these together. Now let's move on to the question of trade secrets and designs and trademarks. The point of designs and trademarks is they are intended to be seen by the public. They have to be known to have their value. The design is the appearance of a commercial product. A trademark is the name associated with that in trade people will recognize as giving an indication of origin or quality. So once they are in the commercial domain, they are clearly not secret and can't be secret to have the value. But the pre-release details may be trade secrets. It can be great value, not for new designs and trademarks not to be known until there is a commercial release, whether it is to fit in with a longer term strategy of naming or design approach, or whether it is just to have the impact of it's all new and to start people talking about it. It also stops competitors doing Me Too type things before commercial release. So keeping things secret up to release, even though they're going to be made public, is itself a trade secret consideration. To maintain trade secret status longer in terms of design, the applications themselves can be deferred in many countries, although not all. So again, this needs to be thought about. But if that option is available, you can protect your design by filing an application, but hold back until it needs to be published at the time when it's commercially released or at a later case. Also, the other thing to recognise is that publication of trademark applications in particular can be very fast. And so the idea that having filed something there may be a lag time before it is public through the trademark registration process is now very, very short. And so that may not be an opportunity that's available to you. So balancing trade secrets and designs and trademarks, often you need to time the filing of your design and trademark applications with your commercial activities so that you're not releasing the trade secret information well before commercialization. Of course, you may want to do that to sensitize the market so that it's ready for it, but again, it's a timing question. So let's look now at trade secrets and copyright. Copyright relates to the form of expression, whereas trade secret relates to the value of the information irrespective of the form of expression. So there are two complementary forms of protection here, and the trade secret value is often the real value there. Copyright does not necessarily require any form of publication, although many rights do run from the date of publication. And publication by definition is not secret. So if something is made public, then both the expression becomes public, but also the information within it becomes public. Unpublished works may still have copyright and trade secret status. Internal documentation, internal communications and pieces of work. We talk in terms of documents now, much of this is electronic, but if it's within an internal environment, it may be entitled to copyright because it is an original work of expression, but the information content itself may also be trade secret status. But simply put, if something is public, you're relying on copyright, just looking at the expression, and you cannot take the information value protected by copyright. So again, we look back at this balance between securing the value of secrecy and the necessity to put information out and make it widely available. A good example where you might see copyright and trade secrets sit together is in software. The software itself is subject to copyright. It is a work that's considered to be a copyright work, but often it is unnecessary to release the inner workings, the source code of software. All you have to see is the external, the executable part of that. And so you may have a situation where there is an interplay between copyright, but you've still got some trade secrecy in how the software works and the limits that are available for people to get access to this within the normal realms of interacting with your software. So trade secrets and copyright, again, they have some levels of incompatibility in the public domain, but need to be considered together to get the best benefit from both. So now we've looked at the interplay between trade secrets and intellectual property rights. We'll now move on to consider how might you protect trade secrets. What are the sorts of things you can do to improve your position? The first thing and most visible thing is that employees need to be able to identify what is a trade secret before it becomes public. So this is one of the most critical things about trade secrets, is that people need to know it's a trade secret. The first aspect. So you need some way of communicating within your organisation that you are what you are receiving and what you are seeing is trade secret information, and it is not public. And that has to be very clear to someone. If they are unsure, you have your first problem, which is people don't know what they're dealing with. The second aspect is, having been presented with a trade secret, somebody needs to know what to do. They need a set of rules to say, this is a trade secret, therefore I can or cannot do these activities. And this is a very important one, because merely telling someone something is a trade secret does not actually impose on them that set of restrictions to maintain secrecy that are necessary, the actions of the holder to maintain the secrecy. Mere labelling is one part of this, but it is only the first part, the sensitization part. The next part is the positive action. And so knowing what to do with a trade secret needs to be expressed very clearly to employees within or other members of an organisation. And what needs to be done is more than just a general set of, it needs to be a secret. The actions that you take to tell people what is and is not disclosure, and where it may or may not be placed, and what sort of activities are necessary, are very important in that what to do section of this how to protect, because this in fact will generally give you a level of protection that you can get before a court. Those things that you have to do when receiving a trade secret are the things that people will look for as not being done or being circumvented. These are the set of rules, and you make your own rules. There are no absolute rules. Now, these rules may be inferred from circumstance, but that's a dangerous position because you don't know what they are. So you need to know what to do when you've got a trade secret. And finally, the underlying part of this is that you have to record and communicate trade secrets internally. People need to know that they are there, and that they've been recorded in some way so they're understood, and that their status is acknowledged, and that if there are any changes in this status, then you need to consider what this may do and how it is to be communicated. It's also important to consider what to look for if a trade secret is misappropriated. So how do you know when someone's taken your trade secret? What are you looking for? Are you looking for new entrants to the market, publications, people starting to say things, changes? So all of these are very important to protect. Identify what it is, know what to do, record and communicate secrets and changes in status, and look for misappropriation. Not everything is a trade secret. You cannot rely on a blanket trade secret status for all information. You cannot say absolutely everything is a trade secret and therefore that's easy. Marking everything as confidential does not work, because if you can't tell what is a trade secret and what is not, how can employees act differently to make sure that the trade secret is protected in a particular way? So the idea of a blanket confidentiality notice on all communications or all documents is not in itself effective. Part of the issue here is that when you do that, there is clearly some things that are not confidential that get marked as confidential. Many of us will have seen the email saying, we're going out for a drink after work, please invite anyone you think might be interested. This email is confidential and should not be disclosed to anyone without permission. This makes no sense. So just stamping everything as confidential doesn't work. It needs more than notification. As I said, it needs to know what is there. And particularly as we know that we have material in most businesses which are external, which are non-confidential, there must be a clear way of distinguishing between them. So a simple blanket approach to say everything is a trade secret and confidential doesn't work. You need to be able to flag things that are and are not confidential, particularly because all businesses at some level need to communicate externally. And so you need to be able to select what is to be communicated and move that into a different status. It's no longer a trade secret and therefore can be disclosed publicly, or it is a trade secret and we need to do something about communicating with that third party to maintain that trade secret status. So a fundamental rule, not everything is a trade secret. Make sure you can differentiate between the two. Underlying all of this, we need an internal process. To deal with all of these issues, processes and procedures are necessary within an organisation, within a company. And the key things that they will often need to cover, well, they will need to identify and record what is a trade secret. From experience, this is one of the weakest areas of process that I've seen. Often things that are secret are not recorded anywhere. There's no common place that you can go to say, do we know what is a trade secret and how it's handled? There's no identification, there's no recording, there's no clear information as to what is there. So an internal process for recording trade secrets is quite important. These can be fairly simple record-keeping systems all the way through to reasonably sophisticated electronic software packages that you can use to keep trade secrets and monitor them and maintain them. Obviously, it depends on the nature of the business, how much is there, but some process that need to identify and record what is trade secret. Having identified those, we then move on to the what to do question. You need the internal procedures for handling trade secrets. And in those you might consider different levels of secrecy. Are there some things that actually need very restricted handling within an organisation, limited to only a few people? Or are these things that can circulate freely within an organisation but should not pass outside? A good example of a very high level of secrecy might be information relating to a due diligence procedure when buying or selling a company. Those often do not circulate very widely. They are valuable, it's buying and selling. So they are very classic trade secret areas that need very high levels of security and very strict limits around them. Some levels of internal activity you just do not publish until you've taken an active decision to do so, but everyone needs to know it's still internal. So there's the procedures are necessary, what are the levels of secrecy, and then you have to make sure that these are followed. There must be some process for knowing that employees are following your procedures. And some of the simplest level are, first of all, you have to tell people what these policies are and explain to them what they have to do. They may need refresher training throughout their careers, and they may need exit interviews at the end to make sure that everything is done that way. Often systems such as electronic access and document management systems will assist greatly in making sure that procedures are followed. Whether you need specific logins, whether there's automatic notification, limits, encryption, all of those sorts of things can be built into a lot of electronic systems. But making sure that these are followed and understood, and that people who have to handle trade secrets know what they've got to do, is quite important. An internal training process and an internal communication process about trade secrets is a very good part of those actions that will get you your trade secret status. As I said before, there needs to be a process for communicating the change of trade secret status. Things that were trade secrets may no longer be trade secrets. A good example is a patent application which becomes published. Up to the point of publication, it may still have trade secret status. After that, it clearly doesn't. So knowing when that status change happens is useful, mainly because it gives someone the opportunity to know that something that was a trade secret is no longer a trade secret and can then be handled differently, with a clear change in status there. And one of the ways that many businesses deal with this is they have some sort of sign-off process for public documents. So things do not go into the public domain without sign-off through various management levels to consider the issue of trade secrecy. And so it needs someone who owns this process to say, yes, this is fine and go ahead, or does it need to be embargoed for a period of time? Do we have to wait for actions to be taken? Do we have to check? So sign-off processes for public documents are useful with a responsibility to a trade secret process. Let's consider employees. As a general rule, employees are the biggest cause of disclosure of trade secrets. This may be accidental because they do not know the trade secret status or know what to do, or deliberate, as a departing employee taking trade secrets with them to a new employer. In a recent survey, 45% of respondents said they found leaving employees were the source of trade secret disclosure. To put that in context, that 45% is set against 53% of competitors trying to obtain trade secret information and 31% customers trying to obtain trade secret information. So that's the actual source of leaving employees disclosing it. What that doesn't take into account is the accidental disclosure by current employees. And this is to some extent the unknown leakage. So employees are the people you have to deal with when you're dealing with trade secret policies. They are the ones who are going to implement it. They need training. They need an understanding of trade secrets, what they are, why they have value, and what they have to do about them. Not everyone will be exposed to trade secrets. There are many people in an organisation who do not need to have access to trade secrets and shouldn't normally routinely receive them. But they should be aware that they exist and know that when they receive things they should not have, what to do with them. Employee handbooks and guidelines are very important places to reinforce this message. And of course, contracts. The employment contract must make clear when an employee is going to be in a job that deals with trade secrets, because this very, very much affects how they will handle and if they misappropriate trade secrets. The argument of the 45% leaving employees source is very common. There have been many cases recently where exactly this has happened. And interestingly, from personal experience, employees who deliberately depart taking trade secrets with them are often not very secret about it. They tend to talk about it way too much and leave lots of trails. Audit trails through emails, looking at employees about to leave, downloading lots of information, but even to the extent of some of them actually saying in communications or correspondence to new employees or to colleagues and friends that's what they're going to do. So departing employees will do this from time to time. As a rule, though, I think it's more likely that it's accidental disclosure because people are not properly informed. So good training deals with both of these. So let's look at some agreements now, which is one of the ways that you would consider to maintain trade secret status. Non-disclosure agreements, NDAs, called confidentiality agreements, or confidentiality terms in contracts, can help protect trade secret status. So if you've got some form of contractual relationship, putting these terms in will be very helpful to maintain the trade secrecy status, because it places the contractual obligation on the recipient to behave, typically in the same way as the disclosure in terms of how they treat the information. But the other advantage of an agreement approach is that it allows the definition of what information is covered. What is the trade secret? What are the specific things that are there? How long is this to be maintained? Who on the recipient can see this information, and what do they do at the end of the agreement? The subject of non-disclosure agreements and confidentiality is quite long and worthy perhaps of a webinar in its own right, but agreements are the way in which you deal with communication of trade secrets outside of an organisation to another one. Just having an NDA is not enough. You need to be sure that the trade secret in question is the subject of the NDA. So merely a blanket NDA doesn't necessarily drag in what the information is that's being covered there. Both sides need to know what it is and how it's being dealt with. And having said that we need agreements with this specificity, there are some cases where confidentiality can be assumed. Commercial confidentiality is a very common sort of issue that is understood by courts and by various jurisdictions, and the normal behaviour can place some degree of confidentiality around it. But if you're assuming confidentiality, it is very important to know what happened at that time. That blanket assumption is as bad as the blanket definition of trade secrets. If you don't know what was discussed and where and in what conditions, whether or not it was confidential is very, very difficult to determine. So agreements are very important for trade secrecy and need to be handled carefully. Interestingly, a good example I came across recently was where a confidentiality agreement was in place to allow disclosure information, but there was no confidentiality about the results of the collaboration that were going to be conducted on the back of this. So one party gave away its trade secrets and let somebody else create something new that could be disclosed without disclosing the trade secret, which effectively put some of its uses out there. So looking at these agreements is a very important aspect, and a proper approach to trade management of these. Non-disclosure agreements are widely used, but they are widely used badly. Often many of them are indistinct. They suffer from specification creep. They start to be used for things that were not intended. They run out without people noticing them. Not everybody knows they're in place, and not everyone knows what's required of them. So while they're a good tool, they're often badly used and can create a lot of problems. So an effective trade secrecy management approach needs effective management of non-disclosure agreements. So we finally move on to the question of other people's trade secrets. And yes, other people can have trade secrets too. So what you need to do is understand, when you receive these trade secrets, what do you have to do? Is there an active agreement in place as to how you will deal with the trade secrets? When you receive a trade secret, what are those specific conditions that you have to follow? How do you store and handle the information or identify it internally so that other people know? Is everyone in a company entitled to see a third party's trade secret or not? So having a trade secret policy for your own trade secrets is important as well for handling other people's trade secrets. And this reinforces the treatment of your own information and treatment of other people's information. One thing to be aware of is unintentionally receiving trade secret material under some form of obligation of confidentiality. This is one of the problems of the blanket confidential or non-disclosure agreement. People telling you things that are trade secret that you don't want to know. That you, just because it's in place, it gets bundled in. And so clear definition of what you receive and what you're going to receive before receiving it is important to maintain your own trade secret status, particularly because if someone tells you something that you're about to find out yourself, it can complicate things quite dramatically. And the other aspect is to be aware of agreements with conditions that differ significantly from the way you handle your own trade secrets. And the same applies for your own agreements. But if someone is imposing an obligation on you to maintain confidentiality and trade secret status that is substantially more comprehensive and stricter than your own internal processes, you're going to have to set up a new process to handle this. You can't rely on your own internal terms. And so there are two aspects to this. One, do you do that? Do you create a confidentiality club and a closed room and these sorts of things? Or do you have a set of internal processes and say those are the ones we're going to apply to other people's information and you tell them so? But again, tracking and knowledge of access and information is very, very important. So other people's trade secrets need to be considered too at the same time. All of the things that have gone before in this discussion on how you handle your own will apply to someone else, and you need to get the interplay right between the two. Dealing with it up front is the way to do this, and recognising where there is a mismatch in approach and how you're going to deal with this is very important to make the trade secret status not only maintained but also enforceable. So let's wrap up with some of the points that we've just discussed. Trade secrets can be a valuable part of an organisation's intangible assets. So I've used the term intangible assets, not intellectual property rights. Information cannot be touched, cannot be handled, but it can be distributed. And this is one of the things that trade secrets do. As we said at the beginning, when surveyed, 60%, 70% were saying trade secrets are very, very important. So having a process that does that does act to a large part to secure the value of your trade secrets and the value that it brings to the company. The act of doing this actually makes things, sometimes makes cooperation much easier. If you are a company that handles trade secrets well and can demonstrate how you handle it without disclosing them, then it's easier for someone to come and work with you in a very close and confidential relationship. It may be important for you as the nature of your business anyway. I mean, we think of things like defence contracting, which has secrecy built around it from day one. But the ability to work in a confidential manner and in a controlled manner gives people a lot of confidence. Trade secrets require careful handling, both internally and externally. It needs understanding, it needs presentation, it needs training, and it needs reinforcement. And the same with external uses. They need to be monitored just the same. Just because it leaves your immediate control doesn't mean to say you don't need to track what is happening. And the final point, which we haven't gone into in any detail here, is that protection varies around the world. So while we have these general concepts, which are what a trade secret is, and that it is possible to do things about unauthorized disclosure and use, what you will get will vary dramatically around the world. And so where the disclosure takes place and where the use of that information takes place will be very important considerations. How you deal with trade secrets, the information requirements, what you can and cannot expect will vary dramatically. Again, this in itself is the subject for another webinar, should it be interesting, but it does need to be considered. But these basic principles that I've talked about today underlie any of those processes. So pretty much any trade secret law or anything associated with trade secret will rely on these things that we have just discussed. And so with that, it brings to the end the formal part of this, and so we will consider if there are any questions. So, I have one question that's been submitting, which is, can pricing information be a trade secret? The short answer to this is yes, of course it can. So pricing information can be confidential. It very often is. A confidential bid is often made that way. And there is value in that information because that may lead to the aspect of that pricing may lead to somebody delivering a contract, accepting the terms, entering into some form of agreement. You can see the value of knowing that, particularly as if nobody else knows what the pricing is, this you've taken action to keep it secret, means that they cannot compete on price. So a pricing, if you like, a tender or a pricing submission can be a very valuable trade secret. It may have relatively short term life. And one of the big problems that you can find with it is that you tend to give it to a customer who will then quite often go and give it to someone else. So controlling your customer in pricing information, trade secret issues can be a real problem. But at the same time, it's quite normal to say that a submission is confidential and it shouldn't be disclosed. If your client's going to go and disclose something, then you have a difficult conversation. But at least you've done everything you can to place it in the right position, and you also know what your customers are like and where they're going to disclose it. So pricing information is a very good example of something which is a very dynamic aspect of trade secrecy. It immediately has all of the criteria of a trade secret, but can immediately drop into a domain where it's very difficult to control. This is that whole point, where it goes out of your control, where does it go to? So pricing information can be trade secret. I think what this leads to is that, in fact, many things can be trade secrets, and you need to have that thought about whether it is or isn't a trade secret. So one of the ways ultimately of dealing with these is that you have a process that deals with how do you deal with trade secret materials. And one way in the past I've found is that you actually prepare a set of information that is not trade secret, that you can publicly disclose. And so one way of dealing with these is having some clear public information that you don't have to worry about being trade secret and restrict to that. And so with that, I'll bring this part of the webinar to an end. I hope it's been useful and that you found these the subjects we've discussed there. We will be emailing links to attendees to allow this webinar to be replayed at a later date. If you have a question or we didn't get to any question, we'll follow up by email in the near future. And please feel free to get in touch if anything arises from this webinar that you would like to discuss with us or any other subject. Thank you for your attention, and goodbye until the next webinar in the IP in Practice series.